Ms. Hall, followed by Judy Bartlett.
Good afternoon. My name is KrisAnne Hall. I'm an attorney, and I represent constitutional education and consulting. I am a constitutional attorney. My job is to travel around the country and teach people about the Constitution. I am on your side in this. I also want to protect the rights of the people. I want to reduce a regulatory intrusion. I want to protect the state's control over health care and her people, enact a good policy for Florida. But I want to discuss something here this afternoon that has not been adequately discussed, another impact of this act on Florida, an impact that I think will have irreparable damage. Now, it is undeniable that there is no power, neither enumerated in the federal government. It is beyond the control of the federal government to compel citizens to purchase health insurance under threat of penalty by law. For the central government to claim such a power denies the very nature of our republic and makes the constitutional restraints enacted by our founders null and void. Alexander Hamilton tells us in Federalist Paper 78, no legislative act contrary to the Constitution can be valid. You can't get much simpler than that. He says, to deny this would to affirm that the deputy is greater than his principal, that the servant is above his master, that representatives of the people are superior to the people. Jefferson says that whenever the general government assumes an undelegated power, its acts are unauthoritative, void, and of no force. The federal government has absolutely no power, no right to create a health care act, and if you want to discuss health care, it must be done on the state level, not through an exchange, but through the power and the authority of the people and her legislatures only. Some claim that it must be submitted to as law of the land, since the Supreme Court made its declaration from on high. This admits that we are not a republic of sovereign states, but a monarchy. The Supremacy Clause declares the Constitution to be supreme, not the federal government. James Madison says that if the decision of the judiciary is raised above the authority of the sovereign parties to the Constitution, talking about the states, dangerous powers not delegated may not only be usurped and executed by other departments, but by the judicial department as well. You see, we have three branches of federal government. Those three branches of federal government are the executive, the legislative, and the judicial branch. To assume that the judicial branch has the authority to decide what is constitutional or not is like looking at a defendant in the courtroom and saying, "Excuse me, will you please tell me if you're guilty or innocent?" That is an usurpation of power, and it is something that our founders called dangerous. The founding documents and the men who wrote them make it unequivocally clear that the states have the final word on whether their creation, the federal government, has trespassed its clearly defined boundaries. Our states are united in a compact that creates the Constitution. James Madison said, in the case of deliberate, palpable, and dangerous exercise of other powers not granted, the states have the right, and this is key, because this is your job now. You not only have the right, but you are duty-bound to interpose for maintaining within your respective limits the authorities, rights, and liberties of the people. The Virginia General Convention said in 1799 that it would be deceitful of those entrusted with becoming the guardians of the state's sovereignty, acting upon an oath that you've taken to support and defend the Constitution, to not fight the encroachments of federal power on the states.
And Ms. Hall, if I could just interrupt for a moment. I'd give you a little more time because several of your fellow citizens deferred their time to you, but maybe if you could spend 2 to 3 more minutes hitting sort of your key closing points, because there are about 12 other people that wanted to speak, please.
No, that's fine. I'm near to my end. You have the right and the duty now to interpose, to stand on behalf of your citizens against an unlawful, unconstitutional encroachment of the state's rights. The powers delegated to the federal government, per Madison, the father of the Constitution, says, are few and defined. He went on to say them to be war, peace negotiation, foreign commerce, external objects, the only thing your federal government is supposed to be doing. He went on to say that all the remaining rights are reserved to the states by their people, which means if the federal government is doing something besides war, peace negotiation, and foreign commerce, they are stealing your power and interposing upon the rights of the people. We have to understand the critical issue of this is that if you allow the federal government to steal state power and mandate upon its citizens that it must purchase health insurance, what then will be the limits of the federal government?
Okay.
I'm not done.
Well, ma'am, I understand that, but as one lawyer to another, I think you should be fair to there's 16, 17 other people who want to speak, and we have 25 minutes.
And I understand, and I'm almost finished, but I also understand that at least 6 people have delegated their time.
Right, and that's why I've agreed to give you extra time. But I would ask. Okay, that's fine. She has been allowed to talk, and she will continue to. Will be able to. Excuse me.
Could I ask the people that are going to waive their time to me to
Hey, ma'am,
stand?
that's fine. I would ask you to please conclude.
I will finish. I will finish.
I would ask you to conclude.
I'm speaking for my 58,000 men that died, so freedom in this country could continue. And I give 2 minutes to this lady to speak.
I will be done in less than 2 minutes.
Thank you, ma'am. If you could please, and there are some other folks that are not,
No, I understand.
that are independent of your group that also would like to speak. So if you could wrap up in a couple minutes, I would appreciate it.
Less than that, yes, sir.
Thank you, ma'am.
Okay. Thomas Jefferson said that the several states who have formed the Constitution, being sovereign and independent, have the unquestionable right to judge of its infractions, that nullification by those sovereigns of all unauthorized acts done under the color of the instrument of the Constitution is the rightful remedy. Nullification is the states standing up and saying the federal government is not our master, we are. The states, the people, are the masters of the Constitution, and we do not have to, nor will we comply with the dictates not enumerated in the Constitution. To deny these states this right is in itself tyrannical and unconstitutional. You have to stand now in defense of the Constitution in honor of your oath. I will submit to you that this is your opportunity to prevent a train wreck. I go all over this country. I speak to groups all over this nation. I am in personal contact with leaders of not only patriotic groups, but religious organizations as well. You know well, just as well as I do, that the Catholic bishops and the cardinals have all stood up and said, we will not comply with this. If you do not stand now, what will you do to protect your citizens when they lawfully and constitutionally stand and say, we will not comply? Because that is something that this committee must take into consideration. As you are considering what you're going to do, a primary consideration will be, how will we deal with the fallout of our citizens, both lawfully and constitutionally saying, we will not comply? If you do not protect your citizens now, what will you do then? I ask you, choose you this day to honor your oath to the Constitution, to the people who've elected you to do a job, and we will be able to choose you again at election time.
Thank you, Ms. Hall. We appreciate your comments. Next we have Judy Bartlett. Ms. Bartlett.